So, for instance, for we call them FMVSS, Federal Motor Vehicle Safety Standards. FMVSS standards, there are many of them, hundreds of them, applying to many different aspects of a vehicle. I mean, as you know, there's 10,000 plus pieces in a vehicle on average, I think. And auto manufacturers love to focus on that and say, well, there's these federal standards and we meticulously complied with the standards. The problem is there isn't a standard for everything. Just because they complied with all of the standards doesn't mean that there was a standard that addressed a specific thing at issue in this defect. And for this case, that was true. There were lots of FMVSS sections that applied to this vehicle, but there was no FMVSS that addressed this shifting mechanism or this problem. And so, because of that, the court agreed with us that they didn't get a presumption instruction. And by the way, not just auto manufacturers. Like, my firm does quite a bit of product liability work in general with all sorts of different types of products. Manufacturers love these presumptions. This is usually one of their lead defenses because if they can convince the court this presumption applies, then an instruction is given to the jury, and then they can tell the jury, you can see it right here in the instructions. It's presumed that this product wasn't defective. That's why they fought so hard to try to get those presumptions in this case. And that was one of the things I'm proud of. We were able to shut them down on both of those presumptions. Court did not give either presumption instruction in this case.